It's a great pleasure to be here, and thank you very much to Professor Sundstrand for inviting me, and it's a great pleasure to be here. I apologize for my lack of Swedish. I think upphandlingskonferensen is, I've learned those over 30 years of doing procurement law, but that's about the limit of my Swedish. I know what that means, so I know I'm in the right place. I'm amongst friends. So as has already been said, by day I deal with public procurement law and a bit of competition and state aid. By night I teach at King's College London, both on the LLM course and on the distance learning course, which also leads to a master's. So I do have a sort of slightly different perspectives as to how our process works. I was asked to talk about the remedies system in the UK, and I was thinking, well, why would you want to know about that? As you know, you have, without a doubt, the most highly functional EU remedies system in the EU, and ours is often regarded as highly dysfunctional. But I thought it might be helpful for you to understand, firstly, what it is that people are criticizing when you read some of the materials about the common law systems, and it perhaps will be sensible to lump them together, the common law systems, but also to have in mind how it does work, but does work in a very common law sort of way, and it works in a way that is distinctively different in the different common law jurisdictions. So there are four distinct jurisdictions, and although the common law that's applicable is fairly similar between the Republic of Ireland, Northern Ireland, Scotland, and England, they work differently as much as anything because of the cultural differences in those countries. So perhaps there's a danger, or perhaps an advantage, that this talk can be more anthropology than law. So, history. One of the oddities, of course, about procurement law in the common law jurisdictions is that at the time of our accession, public procurement law didn't really exist. I mean, yes, strictly speaking, Directive 71/305 existed, so strictly speaking, there was a little bit of public procurement law in the acquis when we acceded, but no one noticed it. In Ireland, the implementation of that directive was a state secret until well into the 1990s. It was not treated as a serious part of the law. And so, unlike those states that acceded later, the states the original 6, public procurement was in one way or another a part of their institutional law. Certainly the French and Italian system and Belgian systems had public procurement law. And later acceding countries, of course, learnt about public procurement. It was when people went off and did their EU law course to learn about the acquis when you accede, public procurement was a chapter that people learnt about. There's something for us that's a bit sneaky about public procurement law. It was sort of put in under the radar. We never knew it was coming, and then we suddenly discovered that it sort of erupted without us ever actually debating it or asking whether we wanted it. It just became. And it doesn't fit very well in the common law system. It is obviously modelled on a legal tradition which is quite alien in many ways to the common law system, and certainly regarded by many English judges as rather alien. On the whole, our systems don't work very well with formal rules-based systems. Whenever we've tried to put in place formal rules-based systems in almost anything, for example, in our old competition law, it's not worked well. We work much better with a law which is just a set of principles which everyone works up and understands. We'd do better if our procurement law, I think, was just Article 18 in the current Public Sector Directive. If we see a whole load of rules, we just see, well, if the rule doesn't make sense, it can't really be a rule. We'll just work around it, or we'll ignore it, or we'll find a way to deal with it. The core cultural issue in remedies is, of course, and people talk a lot about there not being very many cases, and I'll come back to deal with that in due course. The core cultural issue in England particularly, of course, is that you mustn't embarrass anyone. Absolute thing, as you know, in English anthropology, the worst thing you can do is ever embarrass your interlocutor. And so everything is transactional. Everything is about avoiding the moment of embarrassment. And as a result, we go a very long way to avoid going to court, because of course going to court is a moment of embarrassment. It's a moment of loss for everyone involved, because you have lost face just by being there. And people who like being in court are therefore a little bit weird, because they don't actually fit into the cultural norm. It's sort of lawyers and Americans are people who like going to court. And everyone else is, you know, those are the sorts of people who don't know how to queue for buses. And it is relevant. So, but to say that the system doesn't work, I mean, it would be, which some people will say, is clearly an exaggerated proposition. We have, in the last 12 months, have had some really big cases. We have had a case which is well documented, in which our Nuclear Decommissioning Authority has had to pay out over £110 million in damages for a series of rather technical breaches of public procurement law. We have had a number of very high-profile cases concerning HS2, which is the new railway line heading up the west side. So again, there were all sorts of rather shady arrangements being put in place about the way in which the management of HS2 was being run. Those, in fact, which would never have come to light were it not for the fact that litigation was threatened to expose the fact that essentially one operator was managing to win the bid, was sort of revolving its management in and out on a secondment basis between the awarding authority and the winning bidder, and they were just managing to keep themselves going on this enormous piece of infrastructure going forward. Again, it was litigation that brought that forward. And there are now an increasingly large number of claims on a regular basis. It's hard to say. It is true that very, very few of them end up in judgment, so that's part of this embarrassment thing. We go to a considerable, we culturally go to considerable lengths to avoid actually, even when you're in court, reaching a judgment. If you can find a way out of getting a final determination, that's what we will do. So there are a very, very small number of judgments, which obviously has a major impact on the development of our public procurement law, because we don't have many decided cases. We have no judges who have ever done a public procurement case other than our Advocate General and judge in Luxembourg. They're the only judges in all of our amongst all of our judges who have any experience of public procurement law as practitioners. Amongst our appellate judges, only one. In at all levels of appeals, only one has ever actually tried a public procurement case as a first instance judge. So the judicial system is completely devoid of any actual practical knowledge of how you run a challenge or how you decide a challenge. And boy, does it show. We've had two recent decisions of the Supreme Court where some very clever people, or people who at least, well, sorry, no, we mustn't be rude about judges. Some very clever people have said some very silly things because they frankly don't know what they're talking about. They simply, I mean, they don't, they're sort of coming up with a clever construct and that is it's a real problem, because of course in other areas of the common law, the practitioners, the sort of the common law development is based on the premise that judges are barristers who did this for 20 or 30 years, and so when they come to decide cases, they actually are talking about things they have a little bit of knowledge about, and that feeds through into the system. That's simply not true in public procurement. So how many cases do we have? It is impossible to know, because there's simply no way of gathering the data. We have no central register. There's no one place where you can start a claim. You could start a public procurement claim in as many, I haven't recently counted, but I think there's something like 200 different places you could start a procurement claim. And in many of those places, they wouldn't even know how, if you went and asked them, could you tell me how many procurement claims you've had this year, they wouldn't know how to gather the information. My guess, working backwards on the assumption that the chambers I work in probably sees about a quarter to a third of all the claims in England, and then extrapolating from colleagues in Northern Ireland, where I'm qualified, and Scotland, I would guess that we probably have in the sort of somewhere around 500-600 claims a year, probably. That's extrapolating for the whole of the 3 jurisdictions of the United Kingdom. And in the Republic of Ireland, they probably have another 50 or 60, maybe a bit more. So it's not a large category of claims. Because of these to some extent, because of the odd features of the regime and the lack of experience of the judges, we have some rather eccentric views or ill-thought-out views expressed in our law. A decision was taken in 1991 when the regime was first put into legislation to make the remedies as difficult as possible. And that was obviously an explicit government decision to put the remedies system in the High Court, to sort of raise the bar. This was not going to be something easy. There was no going to be easy entry point. And that has been made more difficult over the years because successive governments have started to use court fees as basically a means of tax gathering. And increasingly, court fees have become disproportionately high. For most procurement claims now, you will be paying the equivalent of 100,000 kroner just to start the claim to the court, regardless of what your legal fees are and so forth. And that is clearly part of government policy across the board. Now, there's an issue. Many colleagues have at various times tried to think about how we might contrive a claim to get a determination that fee is unlawful in these cases. I suspect we're running out of time because about the only court that would do that is in Luxembourg. Because we have a structure which is set in the private law system, not in the public law system, unlike in Ireland where it's done in the public law system, typically the judges who are dealing with this area of the law are judges who are steeped in private law disputes. Indeed, the court most of these cases end up in is called the Technology and Construction Court, so what they're used to is contract claims around computers and construction contracts. Their knowledge of public law is often rather rudimentary, sometimes almost undergraduate. So they will have a basic notion that judges should give due deference to the discretion of the decision maker, sort of basic common law notion of public law, but often will not have caught up with some of the more recent developments in the public law courts in the last 30 years since they took their degree in public law. There's a real problem, and they often get, as a result, into quite a tangle in their judgments, because on the one hand, they want to defer to the decision maker, which of course makes it very difficult to run a challenge. And so they will talk about deferring to the decision maker, and then they will realize that actually it's impossible to do that because they will always encourage the defendant, however bad it is, to run a case which says, in any event, it made no difference. However bad I did it, it made no difference because they always would have lost. And then, of course, they suddenly realize that by allowing this argument to be made, they've opened the door to having to retake the decision, because the moment you allow obviously you'll be very familiar with the fact that the moment you allow the question of it would have made no difference to be brought into the arena, you actually have to retake the decision. And so you have a sort of schizophrenic mentality where the judge will be saying, I'm going to defer to the official, I'm going to defer to the official. Oh, but now I'm actually going to have to do the job all over again, which is exactly what I just said I wouldn't do. Which again creates some rather odd tensions in the judgments. What do we have? Obviously the thing we have in common law systems, and particularly in the UK system rather than in Ireland, because it's a private law system, we have full disclosure. And therefore, we're less worried about all the stuff about reasons on a standstill. If you're in a litigious setting, it doesn't really matter very much what reasons you get in the standstill letter. You obviously need reasons to get started, but the reality is, if you're going to be in litigation, you're going to get the whole, not just the Article 84 file, you're going to get every filing cabinet. You're going to get every computer and access to every computer and every filing cabinet, anything to do with this procurement. So, in a sense, it doesn't matter so much that at the beginning you may not get a full explanation. In a way, you quite welcome the fact that the really juicy stuff is only going to come later, because that will enable you to apply tactical pressure by continually broadening the claim. And of course, the other feature of disclosure is that you are able to dig very deeply into what really happened. And that is probably why we do have a large number of procurement cases with truly ghastly facts. I mean, I've mentioned the nuclear decommissioning case. That, once you got into the disclosure and discovered what had really happened, you just couldn't believe that anyone could have been so idiotic. And you would not have found that out just in terms of looking at an Article 84 file of, the official explanation, is it rational? They put forward the whole system had been contrived to put forward a perfectly rational, coherent explanation. It was how they got there that was so surprising. An area that has, if anyone's interested in selling stuff to the UK public sector or your utilities, that is often a point of concern, is the fact that it is said to be so difficult to get a contract suspended. And that's, as a general proposition, true, but again, a bit more colour needs to be put on that. If you read all the judgments, and a lot of the sort of the legal analysis will say that the English courts never, ever lift the suspension. And that's, as I say, true if you look at the reported judgments, with one or two exceptions. It's not actually true in fact, but let me just unpack firstly why we've got there. The reason why suspensions are very rarely lifted is because, again, see the point I've already made, the approach the courts take to deciding whether to lift the suspension is to apply an old House of Lords decision from the mid-60s, which is the general set of principles that we apply in the grant of any interim injunction in any commercial case. And that's a very well understood set of steps. And the key gateway, which is almost impossible to get past in procurement cases, is that because the common law is based on the notion that damages is the primary remedy, if the claimant has an adequate remedy in damages, it won't get an interim injunction in an injunction case. So that was the situation before the suspension, and that regime has simply been continued over in looking at whether or not the suspension should be retained. So the court's first task will be, the first question, well, actually it's the second question, but we don't need to worry about the first question. The second question the court will ask is, if I don't stop this contract from being awarded, if I let the procurement go forward, however bad it is, will the claimant have an adequate remedy in damages? And most of the judges, most of the time, will say yes. Now that's not always true, there are some important exceptions, but that's been the driver towards there being so few occasions when the suspension has been lifted. Now, I think that may start to change. There have been some judges, some appellate judges, who've started to say that really can't be right. It is genuinely rather difficult. And one of the interesting points which we're beginning to try and draw to the attention of the judges in various ways is, if it was so easy, why is it that since 1991, when the statutory regime was put in place, there has been only one decision in the entirety of the United Kingdom where anyone has actually got to the end and calculated the damages? I've got one ongoing case in Northern Ireland where the judge, we succeeded on liability over a year ago. We've had two extended hearings on quantifying the damages since then, and we still haven't had the judgment. It's a very difficult case. It's very difficult to quantify the damages for all sorts of reasons I won't go into now. Perhaps it's reasonably obvious. Excuse me. But the threat of damages is very real. The reason why all of this money gets paid out is because we have this strong cultural drive towards discussing, mediating, avoiding the situation. So what will happen is that in a very large number of cases, if you put in a complaint by way of letter, actually you will get a result. It is surprising how often the authority will back off, change its position, again, because it's part of the culture. It's, oh, I may have done something wrong. Let's see if I can try and deal with it. If there aren't any political constraints, the instinct will be to try and avoid a problem going forward. Once proceedings are started, they are nearly always settled. They're nearly always settled either directly or through mediation, and that is generally done by payment of a significant sum of damages. And the amounts can be very large. I've already mentioned the claim, the nuclear decommissioning claim, and perhaps it's not surprising that a loss of profit claim on decommissioning a number of nuclear power stations would be rather large. But at a more trivial level, I had a case a couple of years ago, which caused a bit of a flurry, all to do with basically recovering cargoes from Second World War cargo ships. And in that case, my client won many tens of millions of pounds for a contract of no great national importance. But again, the government felt obliged to pay quite a large sum of money. The reality is that people do pay out. Authorities feel the need to do that, and as a result, authorities are very defensive. So for a system that doesn't work, allegedly, it's amazing how defensive authorities are. And one of the reasons, again, going back to why public procurement may not be that popular and may have been a sort of one of the reasons which some Brexiteers relied upon, saying, genuinely procurement was a reason to leave the EU for some senior Brexiteers, is because those with experience as ministers are generally are so often told by their officials they can't do this because of procurement law. Now, to be blunt, that wouldn't be true if the system was not in some way functioning. It just may not be functioning in the manner that is either compliant with the rule of law or compliant in the way that the European Commission would like it to work. It's certainly different. Let me just wrap up by sort of slightly looking beyond. I should mention there is a currently theological debate going on at the moment in the UK about whether or not the Frankovich sufficiently serious requirement applies, which is perhaps worth noting. That will continue, but it's only worth noting because it again demonstrates this slight incoherence in the way in which our appellate courts look at public procurement law, because we're not quite sure, having said it was a private law claim, we're then not sure whether or not we shouldn't bring in some public law notions from Frankovich. And that, of course, has been made even more exciting following the recent decision of the EFTA Court, which suggests that our Supreme Court got it wrong, which it did. Let me just sort of illustrate the point about the English system, perhaps by looking at some of the other jurisdictions in the last couple of minutes, to make the point that this is very cultural. Compare with Northern Ireland, which is a jurisdiction I spent a great deal of time in. There's a huge amount of public procurement work in Northern Ireland. Obviously, it's an economy that is hugely state-dependent, and it's a place where the culture and the legal culture is very different. It is a culture where embarrassing people is not a problem. It's a culture of confrontation. It's a culture where the judges assume that government is up to no good, where there's a long history of misallocation of state resources, and the judges have been one of the few institutions who've been trying to stand out for fair allocation of resources against a long history of misallocation. And so there's a sort of long tradition of the judges assuming that they must step in to ensure that jobs and money and so forth are not put in the wrong place. And as a result, the judges, there's a lot more litigation. It ends up in more judgments. The judges are more interventionist. They're more cynical, more skeptical about judicial explanations. It's not a surprise. In the Republic of Ireland, you have another different illustration because they've got a public law system, and so, but unfortunately, their system is perhaps a little bit bogged down in the pace. So while it actually would be quite an effective system, it just doesn't work fast enough. And I should just say that that is the one key feature, perhaps, in our system, is that we do the one thing we do manage to do is get actually decisions taken very quickly now. We can now get most cases dealt with in 2 months, which, given the fact that we have to get disclosure done in that process, that's about as quickly as we could possibly do it. But it does mean that we can get sort of quick final results done. So yes, we have a strange system which doesn't correspond to anything that the European Commission ever thought the Remedies Directive would require. And it is certainly dissident, but it's not entirely dysfunctional.
Thank you so much.